Hello everyone, this is Sean Tassi. I'm a partner in Husch Blackwell's Higher Education Group. We are excited today to give today's presentation on how to respond to a campus data breach. Before we begin, I would like to cover a few housekeeping items. At the bottom of your audience console are multiple application icons for your use during today's programming. I would like to take a minute to highlight a few of the key icons for you. If you have any questions during the webcast, please submit your questions via the question box. We will try to answer all questions during the webcast today, but if a fuller answer is needed or we run out of time, it will be answered later via email. We truly appreciate audience participation and encourage you to submit questions. There is also an icon to assist you in the viewing preferences. Accordingly, please note that you can expand your slide area by clicking on the Maximize icon on the top right of the slide area or by dragging the bottom right corner of the slide area. If you have any technical difficulty, please click on the Help icon. It has a question mark and provides information regarding common technical issues. A copy of today's slide deck is available in the Resource List icon that looks like a folder at the bottom of your screen. This program has been approved for Colorado, Illinois, Iowa, Kansas, Missouri, Nebraska, Tennessee, Texas, and Wisconsin continuing legal education credit. To report your hours in Illinois, Kansas, Nebraska, Tennessee, or Texas, click on the CLE widget at the bottom of your screen and complete the questions. You will need your barred numbers to submit. A recording of the webcast will be available tomorrow for watching and sharing. Once available, a link to the recording will be emailed to you along with a certificate of attendance. Joining me today is Pete Inko. Pete is also a partner in our Healthcare, Life Sciences, and Education group. Both Pete and I spend considerable time dealing with data privacy and security issues as well as breach response. And at the start, Pete and I would just like to start out and say thanks to everyone for joining us today. And although this webinar is part of the Husch Blackwell Higher Education Group's complimentary webinar series, this webinar is a little bit unique in that Husch Blackwell has teamed up with Kakubo, the Central Association of College and University Business Officers, this month. So a special welcome to all the Kakubo members who are participating in a Husch Blackwell webinar for the first time. Today we have more than 400 people participating in the webinar, which is very exciting to us. But as we scrolled through the list of attendees this morning, what was most exciting is the diverse range of job titles on the list. Of course, we have general counsels and attorneys, directors of compliance, chief information officers, but we also have registrars, human resource officers, student affairs administrators, financial aid administrators, finance, business, and operation officers. And we think this is really awesome because data privacy and data breach response is really an issue that impacts every department on campus. And as you'll see, we've really designed this presentation for the entire campus community. Candidly, the writing on the wall is the writing on the excuse me. The writing is really on the wall. Your institutions store vast amounts of sensitive information about your students and employees. And there is an ever-growing group of criminals that want to steal your information. And so the question is not if your institution will get hacked, but when. And that's really what we're going to talk about today is what you can do to prepare for a data breach and what you can expect after a breach occurs. Pete, do you want to walk us through the next couple slides?
I would be happy to. Let's back up Robert Mueller's prognostication from 5 years ago with some real-time data. We have had, in 2017, already 791 data breaches reported. And I'd stress those are only the reported breaches. That's over 4 per day. And that 12.4 million affected individuals means that roughly 1 out of every 25 of us in the United States has been directly impacted by a data breach already in 2017. Translating that into even more immediate numbers, with the 400 of you who are listening in on today's webinar, that means that 1 out of, or actually approximately 16 of you have been affected by a data breach in 2017. Those numbers are absolutely, positively crazy high. And why is this happening? Well, I think it's happening because of that third bullet point on this particular slide, Social Security numbers, and the opportunity for the bad guys to make some money off of you through financial identity theft. It's got to be driving it. from my perspective. So let's look at some other data on data breaches. As you can see from this particular graphic, education is running neck and neck with the financial and insurance market in terms of the number of data breaches experienced. The industry is second essentially only to healthcare, and this is likely due, again in my estimation, to the opportunities that the bad guys see when tapping into college or university servers and the databases that they house. Those systems are rich with information that can be used to make money. Couple that with the fact that higher education, at least in Sean and mine anecdotal experience, appears to have less comprehensive data privacy and security measures in place than other industries. And, well, you get the picture. With that backstory as to why we're talking about data breach preparedness today, I'm going to turn the mic back over to Sean, and he's going to lay out today's agenda.
So today's presentation is aimed at starting to think about how to prepare for a data breach and what to expect when it happens. Although breach preparation and breach response are huge topics, we want to focus really on 5 specific areas today. First, the big picture. What is a breach and what are we trying to accomplish when we're analyzing a breach? 2, what are the primary laws that govern data privacy? 3, what do we do during the first 24 hours of a data breach? 4, what to expect after that first 24 hours? And then we also want to talk about some breach avoidance strategies. So the big picture. The big picture is something that Pete and I frequently step back and think about when we're trying to respond to a breach. Although the big picture itself is simple, I think Pete would agree that breach response can be very complicated. So it's helpful to keep these key concepts in mind as we're moving through the presentation today. And at core, what we're really trying to do is determine what information was lost or stolen and whether criminal activity was involved or are we talking about an accident. 2, does the lost or stolen data trigger any reporting obligations under relevant laws? 3, we need to satisfy any triggered reporting obligations. And then 4, we're trying to limit the backlash of the breach event. And again, as we talk about the various issues today, if you keep this in mind, I think this will serve as a good framework for really what we're trying to do in each portion of the presentation. So there are 4 primary areas of law that govern data privacy. There's state law, there's HIPAA, there's GLBA, Gramm-Leach-Bliley, and PCI. For this presentation, we've lumped numbers 3 and number 4 together. And I'm going to talk about state laws, and then Pete's going to transition and talk about HIPAA, GLBA, and PCI. But before we jump into each of those areas, I do want to point out that a specific law does not have exclusive jurisdiction over specific data. So as this Venn diagram is meant to illustrate, some types of data will be governed by multiple areas. For example, there's situations where bank account information could fall smack dab into the middle of this Venn diagram and be governed by all the types of laws. That's just one example, and it depends on the facts. But I think that's important to keep in mind as we're working through these different kinds of laws today. State laws will typically be one of the major parts of the breach analysis, because state laws govern what we refer to as PI, or personal information. Each state has its own definition of PI, but generally speaking, PI includes social security numbers, state IDs, financial account information, information that if it's lost or compromised could result in identity theft. And occasionally, some states also govern health information under their state laws, but I think that's not generally accepted under all states. Breach reporting obligations under state laws are typically triggered by unauthorized access or acquisition that compromises the PI. Again, a compromise that could lead to identity theft. That's what we're trying to focus on here. And in the event that there is a breach, the state law will likely require you to notify the affected individuals and possibly the Attorney General of that particular state.
Sean, if you don't mind me interrupting real quick, I'd like to amplify that last point that you just made. Specifically, I should mention that breach reporting responsibilities are generally all or nothing undertakings. And what I mean by that is this. Oftentimes we find our clients in situations where they're aware of an incident or an unauthorized access or acquisition of personally identifiable information. And occasionally, it's unclear to them whether that unauthorized access or acquisition has actually compromised the data like you just pointed out. Under those circumstances, our clients sometimes want to essentially straddle the fence. And that is they want to be transparent. They want to be student-friendly. They want to be consumer-friendly. They want to notify the affected individuals of that particular incident. However, at the same time, they're less inclined to want to pick up the phone or send a letter or an email to the Attorney General or the Consumer Protection Agency because they're afraid of blowback. They're afraid of drawing some fire onto them. Unfortunately, though, when you try to straddle the fence like that, what often occurs is that the AG's office or the Consumer Protection Agency finds out about that breach report or that security incident report anyway. They get it through the media. Somebody turns the notification over to the TV station or the local newspaper. When the AGs find out about that or the consumer reporting or the protection agencies find out about that, they often get prickly and they come down much harder on the organization for not notifying them at the outset. So just want to amplify that last point. I think back over to you.
No, that's a great point, Pete. Thanks. I'll also just add on this slide that both the triggering obligations and the reporting obligations under state laws are very can be state unique. But this is the general approach when you're looking at an analysis under the state laws. So I know some of you out there are thinking, great, just tell me what I need to know about my state and I can move on from these slides. But unfortunately, the analysis is more complicated than that. The applicable state law will depend not on where your institution is located, but where the affected individual's state of residence is located. At the time of the event, I should add. So it's kind of an example here. Let's say you have a student from California who enrolls at your school in Oregon, and the student moves to Washington after graduation. Now, which state law applies if the student's Social Security number is inadvertently emailed to a third party? Well, it's going to depend on timing. Before matriculating, California law would apply. While attending school, Oregon law would apply. And then after graduation, Washington law would apply. So although this is simple on this example, with thousands of students and employees, it's easy to see how complicated this analysis can be very quickly if a spreadsheet with several thousand Social Security numbers gets emailed out, and you quickly have to start determining, what law applies to which individual. And I'll add that it's very common to address multiple state laws when dealing with a specific breach. And it's not completely uncommon that you would have to analyze 10, 15, or all state laws depending on the size of the breach. So, Pete, you want to talk about the next couple slides?
I, again, would be happy to. All right, we've already chatted with you a little bit about the state laws. Let's take up the topic of HIPAA and see if we can clear up some myths when it comes to the application of HIPAA in educational settings. So first off, what is HIPAA? HIPAA is shorthand for the Health Insurance Portability and Accountability Act of 1996. And yes, for those of you who remember, that has been around for nearly 20 years now. Anyway, HIPAA protects individually identifiable health information, but here is the kicker. It only protects that health information when that information is held, or if you look on the slide there, created, accessed, used, disclosed, or maintained, to use more precise terms, by a covered entity. And those covered entities are one of three types of entities: health plans, healthcare providers, and healthcare clearing houses. And of those three categories, the only one that likely applies to you, our listeners, is the health plan. And what this means is that the only aspect of your business operations that needs to worry about HIPAA is your institution's health plan. And that activity is typically outsourced. So again, it limits the need to really be aware of HIPAA and HIPAA responsibilities. To say it another way, just because your college or university has health information pertaining to a student or pertaining to an employee, that doesn't make it covered by HIPAA. It may be covered by state laws that Sean just talked about, but it's not covered by HIPAA. Sean, it looks like you want to say something.
Can I just throw one little wrinkle?
Yeah, sure, go ahead.
What about, we get this question a lot, what about the institutions that operate some type of health clinic on their campus that would treat both employees and students?
Okay, so good point. That's a good qualifying issue that we need to flesh out. If we do have on our campus an employee health clinic or a student health clinic and we're providing healthcare services and we're billing for those healthcare services, then that particular component of the institution is indeed covered by HIPAA. But again, it's just that particular component of the institution, not the whole of the institution. So your HR department, things like that, just because they have health information maintained in the files, don't need to worry about HIPAA compliance. That help?
It does, and just the HIPAA piece really applies to the employee component because the student component would likely be FERPA under most situations.
Okay, perfect. All right, so notwithstanding my predictions as to whether you're covered by HIPAA, if you somehow find yourself covered by HIPAA, I should point out that a HIPAA breach only occurs when the privacy or security of the information, the health information that you maintain, is compromised. And that is a very complex decision. Sean and I wrestle with this all the time. You really need to leave that call up to the attorneys. So punt it to the legal department. Let them make that ultimate determination as to whether you've got a breach reporting responsibility. When you do have a breach reporting responsibility, there are two categories of entities that you definitely need to notify. Those are affected individuals and the Department of Health and Human Services. And in some instances, the media also needs to be notified if the breach exceeds a certain amount, which is usually 500 affected individuals. So that is our HIPAA primer. With that out of the way, let's take a little bit of a quick tour through GLB and PCI. So GLB, or Gramm-Leach-Bliley, became law back in 1999. It's almost as old as HIPAA. And among other things, as you can see from this slide, it imposes some privacy and security obligations on what is referred to as a financial institution. Now, we're not going to go into analysis of what is or what isn't a financial institution, but suffice it to say that many of our listeners do qualify as financial institutions. But notwithstanding that, few need to worry about GLB compliance, and that is for two reasons. We'll let Sean amplify this if he wants to, but compliance with FERPA tends to meet the privacy rule requirements under Gramm-Leach-Bliley. And second, although the FTC enforces GLB, it's an open question as to whether a nonprofit entity, a nonprofit organization, is subject to the jurisdiction of the FTC. Did you want to comment on that at all?
Yeah, I'll just say that the FTC, as we pointed out, enforces GLBA. And last year there was some publicity about the jurisdiction of the FTC enforcing GLBA in the nonprofit context and the extent that it's applied. And that's the Senate hearing that I'm talking about really got overshadowed by the election and kind of fell off the radar. But it's something that we're certainly keeping our eye on, and I certainly think that FTC investigations could apply.
Okay, thanks, Sean. All right, that's GLB. Let's look at PCI. Payment card industry, or PCI compliance, is likely much more relevant, much more impacting on your organization's day-to-day activities as it applies to any company that accepts payment card payments. And once that...
Can I just point out one other thing on GLBA? Sure. We got a good question. And yes, your institutions have to certify GLBA compliance with your Title IV funding. So I don't want there to be any miscommunications about that piece of it.
Okay. Thanks, and thanks for your questions. Obviously, we're monitoring them as we go. Back to PCI. Again, I think it's likely much more relevant to your organization's day-to-day activities if you accept payment card payment. And once you do get to that particular threshold, a host of PCI privacy and security requirements kick in. These are very specific obligations. For example, voice over internet protocols need to be addressed. And these requirements are generated by the PCI Security Standards Council, and they're also sometimes unique to each payment card issuer. And while we can't and we don't want to go into much more detail in this limited time that we have together, I should probably point out that if your institution does accept payment card payment, check with your privacy officer, your security officer, your legal counsel to make certain that your organization has attended to all these PCI compliance requirements and is in a good posture with respect to all of those. Sean, I've been talking for a little bit. You want to get back over here?
That's going to move us into our first hypothetical. And poll question, which will follow. So it's 4 o'clock on Friday afternoon. Your CIO calls and informs you that your server used to store electronic files for the Office of Disability Services has been hacked. The server contains, among other things, student medical records submitted in conjunction with a student requesting an accommodation, which leads us to our poll question. What law likely governs the breach analysis? You can click on the first button for state privacy and security laws, the second button for HIPAA, the third button for GLBA, the fourth button, why worry, it's 5 o'clock somewhere. So the answers are coming in. We'll give you guys a couple, 15 seconds or so to click your answer, and then we'll discuss the results. Okay, so we've got a good sample size here. Obviously, we've got some Husch Blackwell attorneys on the line today. Clicking the why worry, it's 5 o'clock somewhere. But the correct answer here is going to be the state privacy laws. As Pete talked about, GLBA is more financial information, and that's not going to really likely apply here. The reason HIPAA doesn't apply is because the disability service is just receiving the medical information in that context. In most situations, is not going to create HIPAA compliance. So it's going to be governed under state privacy and security laws to the extent that that student's residence or that state applies for the health information under state law. We also commonly get questions about where does FERPA fall into this analysis. FERPA, standing by itself, does not contain individual notification reporting requirements, so it's not typically critical to our breach analysis when we're dealing with breach response. With that said, you can report breaches of education records to the PTAC, the Privacy Technical Assistance Center at ED. But under current form, the law doesn't require that. It may change. So when we're looking at the FERPA components of it, we want to make sure we're complying with the FERPA documentation standards on the occurrence of the breach, but it doesn't trigger any individual reporting obligations as it currently stands. And that's something we commonly get questions about, so I thought we'd just quickly point that out here. So now that we've set the stage, let's talk about what you should do during the first 24 hours of the data breach, kind of really the meat of what we wanted to talk about and why we wanted to do this presentation today. The other was just kind of some build-ups. We're all basically operating from the same general level of information regarding privacy and safeguarding requirements. So Pete is going to walk through these points in a little more detail over the next several slides, but we have, let's see, there's a question coming in. Yes, and again, just wanted to say that about the GLBA component under the financial aid, that you are subject to the privacy rules and the safeguarding rules. And I think what Pete was indicating was that compliance with FERPA satisfies the privacy rules, and you still have subject to the safeguarding rules. To the extent there's other questions on that, we can deal with those as they come in. Like I said, Pete's going to talk about the 24-hour checklist, but our entire checklist will be available tomorrow for free with the other materials. But this is kind of a rundown of what you really want to do when you're notified of a breach. The first thing you want to do is immediately record all information relevant to the breach and continue to keep the records throughout the day, because as we're going to explain, timing and information are critical moving forward. Second, you want to contain the breach. You want to stop any additional data loss and fix the issue that caused the breach as quickly as possible. Next, you want to engage your internal and external counsel. You want to hire a forensics firm or consider that. I'll spare you the suspense, and Pete's going to talk about it. Forensics firms are very helpful in these situations. And then you want to contemplate whether you notify law enforcement of the breach based on the information that you currently know. Next, you're going to want to start executing your data breach response plan. If you don't have one in place, your counsel can help you set up that analysis and start working through it. It's primarily going to be identifying the key stakeholders and then really making an institutional decision about how you're going to handle this crisis and how you're going to move forward throughout it. So Pete, do you want to walk us through the next parts of the slide?
I will take over the con here. All right, so we're 20 slides into our presentation. We've burned about a half an hour, and we're finally at the point where we're talking about what you probably came to hear, and that is data breach response. But before we go any further and to delay the conversation just a moment more, I want to take you back to that big picture slide that Sean discussed at the outset and mention that everything that Sean just laid out in that previous slide distills down to our 4 big picture points. First, identify your missing data. Second and third, decide and execute on any reporting duties. And then fourth, manage your risk by doing, among other things, controlling your messaging. So with that refresher, let's go back to that hypothetical and see how our checklist would get filled out practically. But let's just to refresh your recollection on the hypothetical, it's 4 o'clock on Friday. Your CIO calls, says, oops, we got a hacking incident involving a server over at the Office of Disability Services, and we've got student medical records and Social Security numbers on that particular server. So what do? How do you complete that first 24-hour checklist? As Sean mentioned already, as soon as your breach response team is alerted to a potential security incident along the lines of that hypothetical, get out your legal pad, get out your laptop, and start taking notes. The more information that you record contemporaneously, the better off your institution is going to be when it comes to determining the extent of any potential data compromise, when it comes to following up with law enforcement agencies, and when it comes to carrying out any breach notification obligations. The next thing you're going to need to do is secure the crime scene or the accident scene by taking any affected servers offline. It's critical to note here, though, don't turn those servers off, as that would be tromping through the crime scene. That could cost you valuable information about the MO of any bad guys involved in the incident and also the scope of the incident. So once you get your crime scene sealed off, bring in CSI, the Forensic Investigation Pros. Here, it's very important to resist the urge to let your own IT team drive the process no matter how talented they are. And there's 2 reasons for this particular bit of advice. First, the Forensic Investigation Pros have technical resources. They have strategies that come from doing this type of activity day in and day out. And the second reason for trying to ensure that you resist that urge to bring in your own team is that if regulatory agencies, if law enforcement agencies ever are brought into the security incident or the breach response incident, and they question the sufficiency of the investigation that you conducted, you're going to be in a much better posture if you have an independent third party involved. Objectivity is the key. We don't want the fox guarding the hen house when it comes to these investigations. Additionally, and Sean mentioned this a couple times already, you want to contact law enforcement. Oftentimes this ends up being the FBI, and while we may have an initial hesitation to pick up the phone or send an email to the FBI, they can be a strong ally in the security incident response process by issuing what's referred to as a law enforcement delay. And that is basically a notification from law enforcement to your institution to delay reporting the breach or the security incident to the affected individuals until law enforcement completes their analysis of the situation. Oftentimes what this does practically is buy our institution, buy us time to fully investigate the matter and not feel rushed in reporting out what has happened. And we do have a question, and somebody has asked, please clarify what we mean by offline. And they ask, do we mean unplug it from the network or the internet? Essentially, that's what we're talking about. What we're talking about not doing is pulling the plug from the wall and cutting off the electricity flow. We still want this machine up and running so that our forensic investigators can come in and analyze it, but we don't want it connected to your system, your servers, your internet, so that the bad guys still have an opportunity to access information and potentially pull information off your machines or your systems. So with that, let's talk a little bit more about this investigation process and the case for the forensic investigators. I want to do a deeper dive into this idea that it's important to have an independent third party actually investigating your security incident. As I mentioned on that previous slide, the forensic teams have all these technical resources available to them. They've got all these experiences available to them, and oftentimes those experiences, those systems that are available to our forensic investigator professionals aren't available to your in-house team. Now, this particular value add, that added service, that added experience that they bring is key in a forensic investigation due to the massive amounts of data that are often at issue when a college or university server is affected by a security incident. And as you can see from this particular slide, 1 terabyte of data is, as my 10-year-old would say, a lot. It is 1 million 1 megabyte Word files. And any PI, any PHI, any PCI that is on those servers or in that massive amount of data has to be analyzed to determine whether it has been inappropriately accessed or acquired. If you tromp through your crime scene by turning off your affected systems or allowing folks other than the forensic pros onto those systems, you can be in a situation where those individuals have left electronic internal fingerprints on those systems. They've corrupted the crime scene, and they've also complicated the determination as to whether there's been an unauthorized access or an unauthorized disclosure of information on your system. And 2 other points I want to make on forensic investigators, and they're both aligned. One, when it comes to forensic investigators, not all are created equal. Some companies are content to simply point out that you got a problem. They point out what may have occurred, what information may have been compromised, and you don't want those folks on your team. What you do want, or who you want on your team, are the more tenacious forensic investigators, the ones that understand at the outset that their job is to help develop the facts which are going to allow you to conclude unequivocally whether the data has been inappropriately accessed or acquired. These folks have ideas, they go deep. Those are the players you want on your team. How you identify those players is before you get into a situation where you need to engage a forensic investigator is to talk to other folks who have had experiences, because they'll give you the skinny on who went deep and who just gave you a superficial analysis of what may have occurred. Whew. I have talked for a while, and I talked very fast. I'm going to turn it over to you, Sean, to talk about what happens after the first 24 hours.
So the first 24 hours, as Pete indicated, of a breach response moves very quickly. You're making a lot of decisions, a lot of quick decisions, and it can be very overwhelming. But once those correct pieces are in place, things start to move a little slower. They slow down a little bit and get much more manageable. But we commonly get the question of, right away, what's going to happen next? And from our experience, what typically happens next is the forensic investigator often takes about 6 to 8 weeks to complete their evaluation. And it usually costs about $15,000 to $25,000 for their investigation portion of the analysis. Now, those are just general numbers. Actual numbers can be much higher and take much longer depending on the amount of data at issue, how much of the analysis they really have to do to figure out what happened from the breach. But those are kind of some ballpark figures of some recent breaches that we've handled. During the investigation, expect to hold weekly meetings of key campus stakeholders. Hopefully our audio is back. We got a question that was not working there for a second. So during the investigation, you should expect to hold weekly meetings of key campus stakeholders. That's going to also include forensic experts and legal counsel. To the extent legal counsel is on those calls, will likely be covered by the attorney-client privilege if everything's handled correctly. And really, at the beginning of those calls, the forensic experts kind of giving their report as to what they're finding. This allows all campus stakeholders to be informed about what's going on. And it also allows legal counsel to start analyzing the various breach reporting obligations from the different laws that may apply. And although the investigator may take 6 to 8 weeks to complete the investigation, legal counsel can start to analyze, what data has been breached, what laws apply pretty quickly as the information starts streaming in. Then if there's a reporting obligations that are triggered, typically you're going to draft your notification letters and send them to the affected individuals. Point out frequently credit monitoring is provided if you have to report. Some states require that you provide credit monitoring, but it's also, in a lot of cases, best practice to do so, even if a state doesn't require it, because it can really help mitigate any damages associated with a potential breach or with the breach. Because once that credit monitoring is in place, if you're preventing identity theft, you're going to have sealed off the primary damages that would result from a civil suit regarding the breach. Ultimately, federal and state agencies may also need to be notified. Your counsel can help you with that notification and help you navigate those calls to the extent that they're necessary. As we've kind of walked through, it's going to be fact-specific on whether you have to do that or not. And then manage the potential reputational damage throughout the process is critical. Having these meetings will keep your key stakeholders up to speed on what information we're deciding to share to folks as we're dealing with the analysis, if any, and that message is a consistent message and likely coming from one source. So that's what you can expect after that first 24 hours.
Actually, before you click on the next slide, Sean, I can't resist. I got to make a comment here. I can't stress enough how important it is to resist the urge to quickly wrap up an investigation and make a breach reporting decision. If you have an institutional culture that emphasizes transparency or resolving problems quickly, the default is often to conclude that when you've got a security incident, you've also got a breach, and then you've got to send out notifications. And unfortunately, the attitude is, or the position that you have to take, is that if we don't know any better, we have to assume the worst. But such an approach is not always in the best interest of the affected individuals as it can needlessly raise anxiety levels among them. Oh, I've got a notification letter, my information may have been compromised, what do I do now? It can also negatively impact, as Sean has already mentioned, the organization's reputation among students, employees, vendors, and the larger community. And here's something that Sean and I see all the time. So we've used this crime scene analogy throughout the presentation, but when the dust settles on the crime scene or the accident scene, we often find facts that come to light, which indicate that there wasn't an inappropriate access or acquisition of information. And that typically only occurs with time. Again, we got to let the dust settle. So that's
We have one question that I'd like to try to address quickly. The question is, how risky is it for colleges and universities to collect and store student bank account information on their servers? And the typical lawyer answer is it depends. How it's stored and how it's kept. I would say the risk factor in there. But I think one of the things that we try to advise a lot of clients on is why are you keeping that information? And there may be a very good reason to keep such information on your servers, but there's oftentimes not good reasons to keep such information or utilize Social Security numbers on particular documents, basically creating PI out of otherwise innocuous documents. So that's my response to that. It depends, but I think the critical question is, why are you keeping it, and is it necessary for you to do so?
And Sean, amplifying that comment a little bit, at the end of our presentation, we'll talk about this. If it turns out that your institution absolutely positively has to retain that information, there are strategies you can put in place to keep it protected. All right, I think we're good to move on. Let's give you a real-life example. This is an oldie but goodie, just like that Bob Mueller quote at the outset. It's from 2012. It's a case that still offers a whole lot of learning moments. The case involves, as you can see, Beth Israel Deaconess Medical Center. And what happened was this. Again, back in 2012, you had an unauthorized person who gained access to a Beth Israel Deaconess physician's unlocked office. And that unauthorized person stole an unencrypted personal laptop that was just laying out there on the physician's desk. Now, Beth Israel Deaconess knew that this particular physician used that laptop for hospital-related business. And unfortunately, the laptop contained the PHI of nearly 3,800 individuals or patients, and it also contained the personal information of approximately 200 Massachusetts residents. Now, Beth Israel Deaconess had a policy that required employees to encrypt and safely store their laptops, but obviously not all employees followed that policy. 3 months after the theft occurred, Beth Israel Deaconess notified the affected individuals. Before we deconstruct this circumstance, let's throw at you another polling question to make sure that everybody who needs CLE who's listening in can actually get it. So, Beth Israel Deaconess entered into a consent judgment with the Massachusetts Attorney General as a result of this situation we just described. What was, in your estimation, the monetary portion of that agreement? Less than 25, 25 to 50, 50 to 75, or more than $75,000. And I don't even need to wait any further. Everybody's clicked already, and we have an overwhelming reaction that more than $75,000 was involved. And for those of you who assumed the worst, which was most of you, you're exactly spot on. Beth Israel Deaconess was hit with over $100,000 in fines. The kicker is, though, that exceeding that in cost were likely the added requirements that needed to be implemented as part of the consent judgment. So, tracking capabilities on all portable devices, including laptops and smartphones, had to be put in place. Secondly, encryption needed to be implemented for all those devices. Staff needed to be retrained on Beth Israel Deaconess's policies and procedures and the proper way to maintain the privacy and security of individually identifiable information. And finally, annual audits of security systems had to be adopted as well. I should mention that these last 4 bullet points, or however we're going to describe those, on our slide should be baked into your institution's policies and procedures for security incident response. So if you haven't done so already, make sure that your institution's tracking the portable devices, encrypting devices, training staff, and also conducting that annual audit. And especially with respect to that annual audit of security system, if you do have an enforcement action against your institution as a result of a security incident or as a result of a breach, it's going to be important to be able to pull out that audit and show the enforcement agencies that, yes, you do indeed take this seriously. That will mitigate your damages. All right, key takeaways from this. Beyond that little bit of advice which we already gave, what are the key takeaways here? Well, first off, malicious attacks are not always high-tech. You know, we typically hear about coordinated hacker attacks coming out of Eastern Europe, but that's not always the way it rolls. Lost and stolen devices like laptops, smartphones, thumb drives, any of that can result in major and highly embarrassing data breaches. The second key takeaway here is the timing of the notice. Notwithstanding my earlier comments about wanting to avoid rushing to conclusions or letting the dust settle on the facts, here it's a little bit different. There was a clear indication that the laptop was stolen, it wasn't coming back, and that it contained individually identifiable information. Under those types of circumstances, you typically expect notice to have gone out in 30 to 45 days, not the 3 months that Beth Israel Deaconess waited. And by waiting those 3 months, Beth Israel Deaconess may have handicapped the ability of those affected individuals to implement measures to protect their identity and protect their financial accounts. So the last key takeaway here is make certain that your institution has a security incident response plan and has practiced on it. The whole process goes a whole lot smoother, including addressing notification obligations if your organization has one of those plans in place. Sean and I, too many times we've seen clients in kind of a self-created compliance pickle because they don't have one of those plans in place, and or alternatively, they just don't know how to operationalize it. So again, have one in place, know how it works, know how to use it. John, you want to take over the next couple of slides?
Sure. Thanks, Pete. So putting this all into focus, what happens if you don't basically follow the applicable rules, or your security, your data is breached? Couple of different things. As Pete's last example pointed out, really enforcement by federal and state agencies. In the Beth Israel example, the Massachusetts Attorney General was involved in that. Or similarly, federal agencies, HHS or FTC, could investigate and levy fines if that's their determination, or other kind of non-monetary sanctions, such as device monitoring and those types of things, like Pete illustrated with the Beth Israel example. I'd also just like to point out that, I think the agencies, both federal and state, have elevated their enforcement and concerns about data privacy incidents. We're also seeing that attorney generals across states are, when necessary or appropriate, combining forces and resources and conducting joint investigations, I think further illustrating the importance that those agencies within the states are placing on the protection of their residents' personal information. So that's one of the areas of fallout. Second, there's private causes of action, which we've alluded to previously, commonly through the form of class action lawsuits. I'll tell you the first rounds of these breach class action lawsuits were dismissed on most of them were dismissed on some procedural bases based on damages, but I think the plaintiffs' lawyers that are taking these cases are getting much more savvy on how to plead those lawsuits, and they're making it much further. And as we said, providing that credit monitoring is a good defense to mitigate damages or maybe help avoid or at least a factor in avoiding class certification in civil actions to the extent that they're filed. And then finally, reputational harm. Data privacy incidents wind up on the front page of major newspapers all the time. And that's not going to change. It's breaking news and commonly gets reported by lots of media outlets. So I want to move you through one more great recent example of what happens after a breach. In this case, Washington State University's SESRC department conducted some statistical analysis. They collected enormous amounts of data from various agencies, included U.S. Department of Agriculture, the Census Bureau, school districts, et cetera. Included in that information that they were analyzing and working with were personal information such as Social Security numbers and then PHI. And the SESRC stored this information on a hard drive and kept it in what they described as a locked safe. But unfortunately, the hard drive was stolen in April of 2017, and they had to report the breach to about 1 million individuals in June of 2017. I will say that was a pretty quick response from April to June to get those notification letters out. And commonly we were asked about costs associated with these. I don't know what this cost was associated with. We didn't have anything to do with this. Pete and I didn't have anything to do with this response. But I've read that the notifications alone were reported to be up to close to $4,000 in mailing fees alone. I don't know where the enforcement actions are. There still could be the enforcement actions could still be being investigated. I haven't read anything recently on the reports on those. I do note that in July of this year, there was a class action lawsuit filed regarding this incident. So that's unfortunately something that they're going to have to deal with. Again, just an example of what happens after data is breached and you send out those notification letters. I do want to point out, though, that this incident resulted in a lot of negative press, unfortunately. The Seattle Times, in particular, was very critical of the event from what I could see and my readings on it. And this is a picture from the paper, as well as a quote from the story that ran in the article about the incident. And this was the location or this picture depicts the location of where the hard drive was located at the time it was stolen. It's a location off campus, and looking at this building, I don't think you would ever think that 1 million Social Security numbers was stored in there. And further, I think it also illustrates that although criminal activity was involved here, I don't know all the facts supporting this, but one thing that jumps out to me is that someone who stole the hard drive, I don't know that they even knew what was on it. So I think there's a good chance of that. So just a recent example we wanted to bring to your attention. Also want to talk about some causes of breach. I really like this slide for two reasons. The first being that it illustrates, we're trying to move quickly here, we've got a couple of slides and we want to make sure we're done on time. But to me it really illustrates one important thing, and that is that 50% of all reported breaches based on these statistics could really be avoided by eliminating human error. And it's not possible to completely avoid human error. We understand that. But when you think about the enormous costs and embarrassment that are associated with security incidents and breaches, it's critical, we think it's critical, and Pete's going to talk about it in a little more detail, to educate your campus about how they can help avoid these incidents, because so much of it could be avoided if you remove this kind of human error piece. So, Pete, do you want to finish up these last few thoughts?
Let me close things out here. A little bit more data at you, a few more statistics. Here are the latest cost estimates for data breaches on a per person, per record basis. And as you can see, if you do that math from 2013 to 2017, we've got a 20% increase in just a few years. As you can also see, the price of the security incident ratchets up quickly on a per person, per record basis. So once you're in the throes of one of these, look to be spending some money to fix it. All right, we're almost done. Risk management strategies. If your institution is new to data privacy and security risk management, or alternatively, even if you have a robust response plan in place, here are a few risk management strategies to consider. First, absolutely positively, map your data. In the event of a security incident, everyone's job is a whole lot easier if your organization knows the type of data it holds and where it's located. Those two facts can cut down significantly on the investigation time and also lessen the time between the incident and providing notification to the affected individuals if the investigation results in a determination that notification is required. Second, encrypt your data and your devices. We've already alluded to that a little bit, especially with the Beth Israel Deaconess matter. But encryption is generally, or essentially, typically, I guess we describe it, a get-out-of-jail-free card. If your information can't be accessed, it can't be breached, no matter if it's lost, no matter if it's stolen. Additionally, you want to install security solutions such as audit logs on your accounts or on your servers. That's also going to facilitate your forensic investigation. And make certain that your employees are trained as to how to implement basic security measures like strong passwords. 1, 2, 3, 4, 5, A, B, C, D, E are not strong passwords, and unfortunately we're still seeing folks allowing their employees to get away with those types of passwords. More impenetrable passwords with different characters, different combinations of information are much better from a security standpoint. Additionally, you also want to make sure that you have that incident response team in place. Again, we've talked about that a little bit before. That incident response team is typically going to be comprised of your compliance folks, your HR folks, IT, legal, PR departments. Make also certain that everybody knows their job responsibilities and they can be scrambled quickly in the event that you have a security incident. The longer you have to wait to get everybody up and running in terms of response, again, the worse situation you're going to be in. A couple other points. Manage your third-party vendors. They're often the weakest link. That Target breach from a few years ago was caused by an HVAC vendor that had access to Target's systems through electronic billing. And then finally, consider cyber insurance. And before we talk about cyber insurance very quickly, we have our final polling question to see if you're still hanging on with us. Does your institution have cybersecurity insurance? Yes, no, maybe, let us know. While you're, okay, 2/3 of you already have said, well, the statistics are dropping. We're getting closer to 60. Let's go on since we've got about a minute, but it's looking like in most instances you all have cybersecurity insurance. But with respect to insurance, take a look at your policies or encourage your folks to take a look at policies. Oftentimes there's an expectation that your CGL policy or property or casualty policies will cover cybersecurity incidents. As you can see from this slide, they don't. Also know your exclusions. Even if you're in that green column there are oftentimes a lot of losses that are not insured. One other thing I'd mention before we close here is that know your insurance panel. And what I mean by that is oftentimes once you reach out to your carrier to notify them of a security incident, you will be appointed a law firm or a forensic investigator with which you are not familiar. So if you can ascertain who that or what that firm is, who those investigators are in advance, it's going to help you work through that process as there will be that degree of familiarity there. We're at the witching hour. Sean, you want to close us out?
Happy to do so. Thanks for joining us today. We hope the information provided was helpful for you and your organization. If you have not already, please click on the survey icon at the bottom of your screen to complete our short survey. Your feedback really assists us in providing quality future programs. As a reminder, this program has been approved for Colorado, Illinois, Iowa, Kansas, Missouri, Nebraska, Tennessee, Texas, and Wisconsin continuing legal education credit. A recording of the webcast will be available tomorrow for watching and sharing. Once available, a link to the recording will be emailed to you along with a certificate of attendance. The recording will be available for 2 weeks. I think we had a couple of questions kind of stream in there at the end. We'll try to respond to those via email directly. And please be sure to join us for our next webinar on September 26th on immigration enforcement. This concludes our webinar. Thank you.